Шановні колеги, розпочинаємо брифінг на тему доповідь ООН щодо ситуації з
Dear colleagues, let's start the report of UN on human rights situation in Ukraine. And here we have Fiona Frazer as the head of the mission in Ukraine.
Ladies and gentlemen, good morning. Welcome and thank you for coming to the launch of the 26th report prepared by the United Nations Human Rights Office on the human rights situation in Ukraine. This report covers the period from the 16th of February to the 15th of May 2019. Since my last press conference here in March 2019, Ukraine has elected its new president. We commend that the elections were peaceful, competitive, and largely inclusive. Also, the country will form a new parliament in the coming months. We are following the ongoing hearing in the Constitutional Court on this matter. With the new leadership in Ukraine, we believe it is a good moment to present a human rights report with specific recommendations addressed to the authorities, including to the President of Ukraine. I would like to use this opportunity to speak not only about the human rights situation during the past 3 months, but briefly about the last 5 years, as it was 5 years ago that the government of Ukraine invited the UN Human Rights Monitoring Mission to work in the country. I also arrived 5 years ago, just as the armed conflict was starting in the east. 5 years on, the conflict continues. Then, as now, civilians have been affected by the conflict in a multitude of ways. Death and injury are the gravest impact. Since mid-April 2014 until the 9th of June, at least 3,332 civilians were killed and more than 7,000 were injured, as you can see on the screen. This year, from the 1st of January to the 9th of June, we have recorded 70 civilian casualties, 12 deaths and 58 injuries. These are the lowest figures for the entire conflict period, but even one death or one injury is one too many. After the cut-off date of the report, there was another increase in civilian casualties. 12 civilian casualties were recorded in the first 9 days of June. This is equal to the total figure for May. Our message is simple. Until the conflict is resolved, parties must further reduce the number of civilian casualties. And there is a simple recipe for this: full adherence to the security provisions of the Minsk agreements, respect for international humanitarian law, and additional measures to protect civilians in the conflict zone. This is possible, and it has to be done. A woman recently asked us in the conflict zone, "What is the value of my son's childhood? What is the cost of my family separation for 3 years? What is the cost of my father's early death because he could not obtain proper medical assistance during the armed conflict?" Indeed, there is no price for that. And yet, under international law, the government of Ukraine is responsible to provide compensation for the loss of loved ones, for injuries, and for the loss of property. Current provisions of the law on war veterans do not guarantee all civilian victims equal right for compensation. Thus, to avoid discrimination, a comprehensive state policy for compensation for conflict-related losses needs to be established. Since this is the 26th report on the human rights situation in Ukraine, it means that I have more or less stood here at least 26 times. With the exception of the first months, I cannot recall a single time when I was not saying the same things about crossing the contact line and the payment of pensions. There are easy and swift practical steps that can be taken to address these two issues. It is possible to remove unnecessary and disproportionate restrictions of freedom of movement in the east of Ukraine. Simple measures can be adopted to ensure equal access to pensions for all eligible citizens, wherever they live in the country, be it in Kiev, Donetsk, or Lviv. At least two urgent steps need to be taken to ease crossing of the contact line. First, the parties have to agree on the repairs to the bridge in Stanitsa Luhanska, the only and current pedestrian crossing point for the entire Luhansk region. I myself crossed the bridge in April. You can see what older persons, while crossing the bridge, have to undergo, and many have disabilities. Second, there is a need for additional entry-exit checkpoints so that the 1 million people crossing the contact line every month can do so quicker, safer, and with more respect for their dignity. For the payment of pensions, the Ministry of Social Policy has to de-link the right to pension from IDP registration. It also has to ensure payment of pensions accumulated in arrears for all Ukrainian citizens. And finally, on this matter, we call for the implementation of court decisions that have ruled in favour of pensioners, restoring their right to pensions in line with international human rights standards. These two issues, movement across the contact line and payment of pensions, are interconnected. Discriminatory verification procedures imposed by the state to check if a pensioner is indeed an internally displaced person force pensioners to cross the contact line at least once in 60 days. The journey is often horrendous, with hours of waiting either in the sun, in the rain, or in the snow. During the reporting period, at least 8 men and 1 woman died from health complications at entry-exit checkpoints. This has to stop and can be stopped. People we speak to on a daily basis on both sides of the contact line tell us they do not understand why they are subject to such discriminatory treatment. They feel punished and excluded. It divides communities and runs against reconciliation. Equal, inclusive, and fair policies are needed to build trust in state institutions. These factors underpin social cohesion and are essential for sustainable peace building in the country. For the last 5 years, we have documented over 500 individual cases of the use of torture and or ill treatment on both sides of the contact line. We believe, however, that this is the tip of the iceberg, as torture is a systemic issue in Ukraine that was exacerbated by the armed conflict. Currently, the prevalence of cases of arbitrary and incommunicado detention, torture and ill treatment is much lower than in 2014, 2015 and 2016. Yet, we still do document such cases. In many instances, the alleged perpetrators are the state security services and the so-called Ministries of State Security of the self-proclaimed Donetsk People's Republic and the self-proclaimed Luhansk People's Republic. I would like to recall our long-standing recommendation to effectively investigate such cases, old and more recent ones, and to bring perpetrators to justice. In most cases we monitor, this has not been done. For instance, we see no progress in the investigation of arbitrary and incommunicado detention that took place in the premises of Kharkiv SBU from 2014 to 2016. But the Kharkiv SBU is only one of dozens of illegal places of detention which flourished on both sides of the contact line during the early years of the conflict. Another location, for example, is the Izolatia detention facility in Donetsk. More broadly, we are aware of at least 51 detention facilities where hundreds of people were subjected to arbitrary detention, torture, and ill treatment. Justice for these people and accountability for perpetrators is still lacking. We continue to have unimpeded access to official places of detention in government-controlled territory in line with international standards. To prepare this report, my colleagues interviewed in confidence 125 conflict-related detainees. By speaking to detainees, by means of trial monitoring, and by analysing 70 court verdicts in conflict-related cases, we have established that prolonged pre-trial detention is used to pressure defendants into pleading guilty. Prolonged means that some defendants have spent more than 3 or 4 years in a CISO. Court administration and judges should consider alternatives to pre-trial detention when trials become protracted. In territory controlled by the self-proclaimed Donetsk People's Republic and the self-proclaimed Luhansk People's Republic, neither we nor any other international monitors have regular, unimpeded, and confidential access to places of detention. Such access, in line with international standards, must be provided to international monitors, including the United Nations Human Rights Office. It would serve as additional protection to all those detained across the contact line. We have reasonable grounds to believe that the denial of access is to prevent the international community from seeing and documenting human rights abuses. During the reporting period, we welcomed several legislative developments. One of them, the establishment of the Commission on Missing Persons, that will coordinate the efforts of the government to clarify the fate and whereabouts of individuals who are missing due to the armed conflict. The government, though, has to provide sufficient resources for the effective operation of this commission. The law on the state language was adopted in April. While it is the legitimate right of the state to strengthen the role of its official language, a special law needs to be developed to ensure fair correlation between the protection of linguistic rights of minorities and the preservation of the state language as a tool for integration within society. 5 years on, the Russian Federation, as an occupying power in Crimea, continues to deny the UN Human Rights Monitoring Mission in Ukraine access to the peninsula. It thus disregards the relevant UN General Assembly resolutions. Since the beginning of the occupation, the Russian Federation imposed its legislation in Crimea. This direct violation of international humanitarian law affects all residents of the peninsula on a daily basis. Its impact is everywhere. The Russian Federation has imposed its citizenship on Crimean residents. It has forcibly transferred from Crimea Ukrainian citizens who failed to comply with the Russian Federation immigration laws. It has deported prisoners in Crimea to the Russian Federation. Individuals denouncing the occupation, pro-Ukrainian activists and others have faced intimidation, harassment, and imprisonment. Specifically, Crimean Tatars have suffered from raids of their homes, religious places, and business premises, which in many cases have led to arrest. The word that I most likely said the record number of times during the past 5 years at such press conferences, at various meetings and events is accountability. And the second word is lack. Lack of accountability is a systemic issue in Ukraine that must be addressed. We need accountability for the range of human rights violations and abuses that derive from the conflict, as well as violations of international humanitarian law. These are killings, enforced disappearances, torture, ill treatment, sexual violence, arbitrary and incommunicado detention, and pillage. 5 years have passed since the killings at Maidan in the winter of 2014, as well as the killings and violent deaths in Odessa on the 2nd of May that same year. Investigations and trials have been protracted and ineffective. While we acknowledge some progress in investigations carried out by the Prosecutor General's Office, there is still no accountability for the 98 killings at Maidan, nor for the 48 killings and violent deaths in Odessa. Likewise, accountability for killings and attacks on human rights defenders and media professionals is yet to be achieved. For example, the trial into the case of the journalist Olyes Bouzina, killed 4 years ago, will now start from scratch, delaying justice even further. The trial had lasted for 1 year and 4 months. Then, in May this year, the presiding judge recused himself. Next month will mark 3 years since the killing of another journalist, Pavel Sheremet. The investigation is still looking to identify the perpetrators of this crime. While 5 individuals have been convicted for the lethal attack against Katerina Handzuk, those who ordered and paid for this crime have still not been brought to justice. And while in February, March, and April 2019 we saw a decrease in the number of attacks against media professionals, 2 brutal attacks happened in May and June in Cherkasy and Kharkiv. We call on law enforcement to ensure prompt and efficient investigations into all attacks that hamper civic space. Noting certain improvements with regards to freedom of assembly, the report reiterates lack of accountability for previous attacks on assemblies that took place in Kiev and other cities. Since mid-May, however, we documented an increase in attacks against LGBTIQ persons and Roma, when 4 of their events were disrupted by extreme right-wing groups. Respect for fundamental freedoms is essential for peaceful and inclusive elections, with impunity being a risk for civic space. In territory controlled by the self-proclaimed Donetsk People's Republic and the self-proclaimed Lugansk People's Republic, civic space remained highly limited. All assemblies there were reportedly organized by those in control of the territory. In addition, at least 2 media professionals remain in detention in Donetsk. So, while lack of accountability is the key challenge to be addressed, we do see prospects for enhancing human rights protection in Ukraine. I've already mentioned certain immediate steps that could improve the human rights situation in the country. On the bigger picture, our key recommendations are the following. First, I encourage the President of Ukraine to support a culture of accountability and respect for the rule of law. More needs to be done to combat pressure on judges, to reform the General Prosecutor's Office, and to ensure adequate resources for the State Bureau of Investigation. Second, the self-proclaimed Donetsk People's Republic and the self-proclaimed Luhansk People's Republic must provide to international monitors regular, unimpeded, confidential access to all places of detention in accordance with international standards. They must treat all detainees humanely in all circumstances. Further, I reiterate our position that those in control in the self-proclaimed Donetsk People's Republic and the self-proclaimed Luhansk People's Republic are responsible and shall be held accountable for human rights violations committed there. Third, we call on the Russian Federation, as the occupying power in Crimea, to uphold its obligations under international human rights and humanitarian law. It means, among other steps, to not enforce its legislation in Crimea, to ensure humane treatment of all detainees, to allow freedom of religion to all groups. The Russian Federation also has to comply with the orders on provisional measures issued by two separate judicial organs within the UN system. The first order, as of 2017, is from the International Court of Justice. The Russian Federation has to lift its ban on the Mejlis. The second order, as of May this year, is by the International Tribunal for the Law of the Sea to immediately release 24 Ukrainian crew members and naval vessels seized in November last year near the Kerch Strait. To conclude, the people of Ukraine, whom we speak to every day, say that what they want and all they want is peace and respect for human rights. This should be at the core of the agenda of the new government of Ukraine. Thank you.
Чи є запитання до пані?
Any questions to Ms. Fiona? Then we express gratitude to Fiona for the presentation and for the briefing.